Welcome to a presentation regarding Louisiana expungements presented by Carl Barkemeyer, attorney at law. So what is an expungement? An expungement is the removal of the record of an arrest and/or conviction. Why would someone want an expungement? Well, a criminal record can negatively impact employment opportunities, education, getting into school, also getting the financial aid for school, can limit access to government assistance, and also having a criminal record can just be bad because anybody can go to the courthouse, run your name, and see what your record is. So who is eligible to obtain an expungement? Well, misdemeanors and felonies of certain types can be expunged. First of all, the case has to result in a dismissal. So there's a few ways that can happen. One is time limitation to prosecute can run out. The prosecutor can agree to dismiss the case. The defendant can win the trial, or a motion to quash could be granted by the judge. The most common form of dismissal is pursuant to Article 894, in which case a defendant will be placed on probation, complete the probation, all the required conditions, not get in any more trouble, and the judge can set aside the conviction and dismiss the case pursuant to Article 894. Regarding felonies, same thing, got to result in dismissal. And so the ways that can happen is time limitation to prosecute can run out. A prosecutor agrees to dismiss, can be acquitted, motion to quash granted, or dismissed pursuant to Article 893 in the same way as Article 894. It's just 893 is for felonies. Charges that cannot be expunged include charges that have conduct leading towards sexual acts and domestic violence cases. The process to obtaining expungement basically starts with you got to file a motion to expunge. It's common that people believe that sometimes an expungement's automatic after they're done with the case, after the case has been dismissed. It doesn't happen that way. You have to file a motion to expunge to make the record removed. The DA or the prosecutor has an opportunity to object. There can be a hearing that could be set, in which case your attorney would have to argue with the DA as to why the expungement should be granted. At that point, the judge can sign the order granting the expungement and ordering the various agencies to remove the record. The clerk will serve the order to the state police as well as the arresting agency. The agencies then remove the record. So how long does it take for an expungement to become completed? The process can take up to 1 year. However, it can take up to as little as a few months. It just depends on the state agencies and how fast they're moving. It's a bureaucratic process that does take a little while, though. So when can you file an expungement? Anytime after a case has been dismissed, after a motion to quash has been granted, after the DA decides not to bill it, or you complete the pretrial program. However, with DWI pretrial, you have to wait 5 years before you can file for an expungement. Also, another common way is after the 894 or 893 has been granted by the judge, which occurs at the end of probation. If you never go for your 894 or 893 hearing, and the judge never sets aside the conviction, well, you need to have your attorney go to court, file a motion, go to court, and get the 894 or 893 granted and have the conviction set aside. After an expungement, who can see the record? Law enforcement agencies will still have access to it, as well as other listed agencies in the statute. And these involve a lot of professional organizations. So definitely consult with an attorney regarding that issue. How much does it cost? Well, it varies by jurisdiction. Generally, filing fees are a few $100s. Sometimes they can be less, but it just depends. So if you're interested in filing an expungement and you need some help, you can contact Carl Barkemeyer, attorney at law, and he'll be able to help you. Information in this video is not intended to be formal legal advice, nor has it created an attorney-client relationship.